Welcome to We the Plaintiffs, a podcast built specifically for law students destined for the plaintiff's bar and the courtroom. My name is Corbin Winward. I am a rising 3L at Baylor Law School, where I currently serve as the president of the Baylor Plaintiffs Law Association. Just a quick note before we dive in. I am a law student, but nothing on the show is legal advice. Also, the opinions expressed here are strictly my own and my guests, and they do not represent the views of Baylor Law or any other institution. So with that out of the way, our very first guest on the show is Professor Jim Wren. Professor Wren is a Baylor Law graduate, a longtime trial lawyer, and one of the people most responsible for shaping Baylor's reputation in advocacy and trial practice. He earned his JD cum laude from Baylor Law and later completed an MA in International Relations, University of Kent at Canterbury. Before joining Baylor's faculty, he built a distinguished practice in business litigation, including business, fraud, professional liability, and repeatedly recognized as a Texas super lawyer in business litigation. He has also written extensively on trial practice, including proving damages to the jury and other major practice materials used by Baylor lawyers. At Baylor, Professor Wren has taught generations of students the discipline, preparation, and persistence that trial work demands. For law students interested in advocacy, he is someone who has spent both a career trying cases and a career teaching others how to stand up and do it well. He recently co-founded Wren Cook, a high-stakes litigation firm. Thank you for being here, Jim.
Corbin, glad to be with you.
So we talked about your background briefly, but what has your overall career path been since earning your JD? Can you explain that more?
Well, I spent the first 16 years of my practice on the defense side doing civil trial work. Started out doing med-mal work, expanded from that to other forms of professional liability that carried me off into increasingly financial litigation, and as well as some defense of direct personal injury work. But increasingly over those years, I was moving more and more to plaintiff's work. And finally, after 16 years, my plaintiff docket was larger than my defense docket. It had continued to grow, so I made a move into a pure plaintiff's firm at that point. Spent, about 9 years doing that before being asked to come in and join the practice court faculty at Baylor Law. I told my partners I'd be back, yet I was going to do that for a period of time. I did not know it would be 19 years, but I taught PC for 19 years. I continued trying cases as my schedule allowed during that time period. Number one responsibility was teaching students how to try cases. And then last year, in 2025, I finally carried through on that pledge that I would return to a full-time trial practice, and did so. Now we have Wren Cook. So that's kind of the overview of my practice background.
Awesome. So you mentioned Wren Cook. Can you tell me and the viewers more about that firm you recently started?
Yeah, I'm in practice with Louis Cook, who is excellent trial lawyer. In fact, one of my former students, as well as of counsel with us is Louis Fraley, who is the current director of the Baylor Practice Court Program. We focus primarily on plaintiff trucking litigation. We've got some cases in some other areas, but that is the great majority of our work is plaintiff trucking litigation. It's all plaintiff litigation. And we are involved in cases in multiple states. What is a little bit unique about our trucking litigation is that despite it all being plaintiff side, about half of it is, or a little over half of it, is for catastrophically harmed families in trucking. But then the other is representing trucking companies that are going, good trucking companies that do it the safe way, that are going against bad trucking and freight brokerage companies that are basically determined to deliver the lowest cost product regardless of safety or lack of safety. And that's the primary focus of our litigation.
Great. Yeah, it seems to be a trend that's getting more and more dangerous to be on the road from the little research I've done.
Unfortunately, you're right. It is.
I think in the panel we did at our school, and I think on your website it mentions how some of the work you all have done has kind of shaped companies to make better choices. Is that right?
Yes, I mean, that really is the point of our litigation. We're going after bad systems in the hopes of forcing accountability for that to hopefully make bad systems into maybe even reluctantly so good systems.
Yeah, that's great. So why plaintiff's law for you?
Well, I started on the defense side, and what I care about and came to care about was making a difference. And I found on the defense side, I represented some very good people on the defense side. It's not that I am against the idea of defending cases, but there are at least a couple of primary differences from plaintiff side versus defense side. On the plaintiff side, I have the opportunity to very carefully select which cases I'm stepping into, and I select cases where I feel like there is a real opportunity to make a difference, a real difference. On the defense side, I represented folks that were good people. I represented some defendants that would not be my choice to defend. I defended them to the best of my ability. Oftentimes, we were getting our cases through insurance companies and clients that we represented on an ongoing basis, and we didn't get to pick our spots, pick our cases. And I very much like being able to do that because I just think it's important to absolutely believe in the purpose that you are seeking in litigation. And I'll mention as a secondary aspect, I'm not a big fan of keeping every minute of my time. I would rather just simply be focusing on the work that matters. And so that wasn't the main reason, but it was one of the advantages of moving to the plaintiff side.
Yeah, for sure. So Jim, you're an author and you've told me your next book is targeted for publication at the end of this year. Is that right?
That's right.
Can you tell us more about that book coming out?
Yeah. It's a roadmap for how to select cases that truly make a difference, and then how to prepare those cases for trial from day one. You begin with that purpose in mind. So it's covering early case assessment, identifying the conscious violation of known rules, known safety rules, doing focus group jury testing, building a discovery plan, developing the trial plan as you're moving out of discovery. It's basically the roadmap for how to pursue and hopefully prevail in the litigation where you're going after bad systems and seeking to make a difference.
That's great. Cool. I look forward to that coming out.
Thank
You've
you. I'm
given,
looking forward to it coming out.
yeah, you've given me advice before on the importance of a routine, especially with I have practice court coming up, as you know, my third year, but
It's
importance of
always fun.
routine. Yeah. Well, 19 years, I'm sure you've seen a lot of students go through and get through that. But just in general, I know this podcast will go to students not with that program, but you said a routine's important for like classes and harder course load parts of our law school experience. So can you talk about kind of a routine?
Yeah, I've learned along the way that both trial work and law school are closer to marathons than to sprints. You've got to be willing and able to go the distance. That is certainly true in preparing cases for trial. And you learn it, and very intentionally at Baylor by design, where frankly, I'll just be right up front about it. The practice court experience is designed to give you more work than you have time to fully perform, at least the way you've always done it. In
Yeah.
other words, it is intended to put you under time pressure because that is a great learning experience. I mean, it's a crucible. And so learning how to move past the way you've always done it to adapt, that is an incredible teaching opportunity, learning opportunity that you will repeat, that I've repeated multiple times in my career as new challenges come along. It's that mindset that yeah, this is tough, but I also know I can handle this because I've learned how to handle this kind of pressure. But in doing that, I think it is so important, so crucial to figure out a systematic approach, a routine approach. And what I have through the years told students, learned to tell students is, um, don't think, oh, I'll just keep going, burning the proverbial candle at both ends and it'll all turn out right. No, it's a marathon.
Yeah.
You've got to have a repeatable routine that works over the long haul. And the first thing I emphasize is you've got to set up as a really kind of a hard boundary the sleep you need. Not maybe all the sleep you want. Maybe I would prefer to sleep 9 hours a night. Maybe that's not going to work. But I learned this. I learned this in practice court when I was going through it. I certainly learned it and relearned it in multiple trials. You have got to protect your ability, your focus, your energy over the long haul, of a trial, preparation for trial, certainly in practice court. And for me, and I suppose everybody's a little bit different, but for me, that means when I'm under real pressure, I still need to protect about 6 hours of sleep a night. There may be some that can get by with a little bit less than that, but don't cheat the sleep. And so, number one, figure out what do I really need in order to keep going? And then prioritize from there. What I've found is if you are continuously changing up the routine, you are continuously changing the hours, your sleep hours, your work hours, it just becomes hit or miss. And so I emphasize, get on a routine, get on a schedule that works for you and stay on it. That really is how you get through. And then don't be afraid to adjust the way you've done things. I'll give you an example of that that's specific to practice court. When I was going through Baylor Law a long time ago, but we had practice court system there, just like we have it now.
Mm-hmm.
When I was going through that, I learned to outline my courses, and that was great. Except when I got to PC, I didn't have time to outline the way that I'd always done it. So I learned to adapt. Instead of building the full outline like I had wanted to do, routinely done for my courses before that, I started learning to read the cases, and there were masses of them, read them, highlight them on my read through, label, what's the fact, a situation, what is the issue, what is the holding. I wouldn't put that into an outline. I was literally putting it on the face of the case so that it was there available to me when I would be called on in class. And also don't think you're going to remember every case you read off the top of your head. You've got to be able to quickly go back to a system. Well, the point here is that may not be the exact system for somebody else, but don't be afraid to adapt. Figure out what works for the limited time you've got, get a routine down, and go to it. It is a marathon. It's not a sprint.
Yeah. So you're kind of saying it's like the analogy with the rocks and the sand. The rocks, you need to sleep there, and then you can build your time around that. And then when it comes to classroom stuff, you can build what you need and what you can actually accomplish in the limited time you have to prepare.
That's it. I mean, the hours you got, figure out what is the highest priority. How am I going to get that done? Maybe not ideally exactly the way I've always done it, or ideally would want to do it, but it's what is available to me, and then stick to it.
Yeah, and I mean, that's great advice for trial prep too. You got to have that marathon mindset for weeks of prep and
do.
Yeah, cool.
That's exactly right.
Thank you. What are some of the biggest changes you've seen, Jim, in legal practice as a whole and then trial work since you began practicing?
Well, that's a good question. First, I had to get past the idea, and I did have this idea in mind that starting out that, I'll try a few cases and I'll get past the feeling of stress at the beginning of or the lead up to every case. And I came to learn, no, that's part of it. And that willingness to live with it's not like your whole life is stressful, but I'm telling you, the lead up to trials, still after 45 years of trying lots and lots of jury trials, it's still stressful. It's still a gut
Mm,
twist. So
yeah.
learning that was not going away, it also was not debilitating. It's not fun. The stress part is not fun, but although I will say I love being in trial, I love the cross examination in particular, but the lead up to trial has never been fun. And so I had to learn that and adjust to that. Probably second is the recognition. I think I had in mind that I would become a specialist in some relatively narrow area of
Hmm.
trial work. Like I started out doing medical malpractice defense. I thought, okay, I'll become an expert in medical malpractice defense. And then, as I've already mentioned, my cases, what provided opportunities to learn. I loved the learning process. And over time, I came to recognize, no, it wasn't about becoming a specialist in some substantive area of trial work. It was about becoming a specialist as a civil trial lawyer.
Mm,
Through the years, I have tried the full range of civil cases. I've not been on the criminal side, but on the civil side, there is an acquired mindset that, yes, a civil case, I can learn this area. It's about understanding how to take cases to juries and how to talk their language.
yeah.
And probably third, I think I'd be remiss if I didn't mention this, that we have to, this has become increasingly true through the years. If we're going to try jury trials, we have to be very intentional about going in with that mindset of, I'm not sure which, the majority of my case, I settle the majority of my cases, but I am routinely trying one out of 20 or one out of however many,
Yeah.
15, 20 cases. I never know which one that's going to be. It's which one
Yeah.
doesn't seem to have a reasonable opportunity to get it fairly resolved. So I have to approach every case with the idea that this could be taking to trial this year. And um, I have to be very intentional about going through that gut twist prep time, that's just part of it. I see today increasingly lawyers that never quite get around to trying cases. And the longer that goes on, the more unlikely it is that they will ever try cases. And if you're
Yeah.
going to try cases, you have to be very intentional about seeking out those cases to try.
Yeah. Yeah. You got to keep that muscle going.
That's exactly right. Very much so.
So, with kind of the changes in general to law, I know we talked about you're helping develop some legal AI currently. Is that the right way to say it?
Yes, but with a caveat. I'm the trial guy. I'm a lawyer that's been working without AI for almost all of my career to the last 5 years. And so I'm very much not the technical expert. I am blessed to work with some great experts, including Joshua Weaver, who is director of innovative technology and director of Texas Incubator program for the State Bar of Texas. There's where the technical expertise comes in. But yes, I am a great user of legal AI, including the legal AI tools, litigation AI tools that we are developing, kind of like we kill a bear. Joshua does the technical work, but I'm advising on what do they need to be able to do and what will I use them for. So I'm a big believer in applying AI the right way to litigation, but it'd probably be a misnomer to say that I am any sort of AI expert. I am an AI user.
Cool. How have you? I mean, I'm sure law students understand this. We use it for outlining and everything in law school, but how have you seen AI help in your practice?
Well, we're developing the tools literally the way that I have learned over 45 years of trial practice to build cases for trial, where we are building the AI litigation tools to help lay out the early case assessment, to help identify the safety case rules, the themes, potential themes of the case, to help us with jury testing on a very rapid and efficient sort of basis to translate that sort of information into the discovery plan for the case, to take the discovery that's coming into the case to help build out the trial narrative. Uh, so AI is being designed, especially agentic AI, is being designed to work in a very specified format, the way that trial lawyers work. And that has helped me immensely. It doesn't replace my thinking, but
Yeah.
boy, does it speed up my thinking and help me see the potentialities that are out there. It's still going to be my judgment as to what to keep, what to modify, what to say, no, I don't think so. But it is giving me, and I should have mentioned some other areas, as being able to do online uh, day scripts where we can
Hmm.
get and compare masses of information that 5 years ago would have taken a uh, very large and expensive team a lot of time, oftentimes months at a time to develop the information that we can be scraping in literally days or less. It is amazing what is out there. AI will not replace trial lawyers, but I think the trial lawyers that understand how to use AI as a great equalizer will outperform and replace those who do not.
Yeah, that's something I appreciate. Professor Corden at Baylor Law is trying to incorporate it in every way possible in all the writing classes and helping us
Yeah,
have familiarity with it before we go out.
yeah. Corden is great at has very much gotten a vision for that. He's also working closely with Liz Fraley, who director of the practice court program, who is implementing it there. In fact, she is helping lead the AI charge for a vote of the American Board of Trial Attorneys.
Wow.
So Baylor Law is very blessed to have some people that absolutely understand and see the vision. We just in this summer, the advanced trial prep class, we were beta testing litigation, AI enabled litigation tools, and learning a lot from that beta testing, what was working well, what still needed improvement. So the fact that Baylor is recognizing the need to keep pushing forward, I think is very important.
Yeah, that's great. I think personally, the hardest part of law school and probably the most important part is you're all prepping for that first job. That's what your summers are all for. That's hopefully what your classes are gearing you towards. So, what kind of advice do you have for law students that are trying to decide what that first job should be? Like what firm or hopefully plaintiff's law if they can find it. But what general advice, I guess, do you have for those students?
Well, I think it's important first to use internships and clerkships to learn what you really care about. I mean, honestly, when I came to Baylor, I had been around some trial lawyers and I came to Baylor. I selected Baylor because of the practice court experience, because of then Matt Dawson. But I did not know whether I really wanted to be a trial lawyer. I was interested in it, but I also thought maybe business law, and just even going into the business world, just as a legally trained, but nevertheless not practicing law, that was a possibility for me. I didn't really know. And I've found with the great majority of students, not all, but the great majority of students, come in with that kind of, anything's possible mindset. I'm not sure. I have some ideas about what I want, but I don't really know. And I also, when I was coming through, even if I was thinking if I do trial work, I don't know what that means. First big question for me was criminal versus civil. Then on the civil side, does that mean defense? Does that mean plaintiff? Truth is, I did not know. And so I started on the defense side, as I've already mentioned. But the quicker you can have exposure to various types of practice and understand why lawyers are engaging in that, I think the the better you can start to target where you may want to be networking, where you may want to be reaching out. And for folks that really understand that plaintiff's work is attractive to them, maybe because it does offer the opportunity to select cases where you can make a difference for folks, or for whatever other reasons, that will help identify the networking that you really want to focus on. But I'll also say that it may be that even if you don't start out on the plaintiff side, your focus is, I want to get trial experience. And that can be making the decision to go the district attorney route or the public defender route, or to even get into insurance defense work that might give you trial experience. If trial experience is important, and I think it should be important for those that are ultimately going to be going to a plaintiff's role, then that can be important. But what is it you really want to learn? What is it that you want to ultimately be pursuing? And then I think it's important to figure out in those internships, clerkships, what kind of people do I want to be working with, that are holding what kind of values, what kinds of things to be important, and then be very intentional about the networking. And by networking, I mean not just I'm all for answering the interview opportunities that come through Baylor. There's so many great interview opportunities that do come through Baylor.
Yep.
But also reaching out and expressing a desire to treat certain types of lawyers and certain types of firms as sages, if you will, gurus in the area. And even if they're not interested in hiring, not interested in interviewing you, I found that if you express a real desire just to have the ability to sit down for a half hour or an hour with an attorney who's in the area that you want to be in, and just be a resource for you in terms of helping you understand that area, oftentimes they become advocates for you. They're starting to give you, if you ask, they'll start to give you ideas of who else you might want to talk to. And if you
Yeah.
talk to enough folks, you're going to run into people that probably are going to have an interest in hiring you. I just think networking is an incredibly beneficial way to approach things. And if I might, I'd add one more thing. And
Yeah,
it's
of course.
don't get too hung up, at least in my view, on what is the highest paying position
Yeah.
to start out, or what is even the most prestigious position. If you are finding the places, the opportunities where you can learn within reason, make those the priorities.
Yeah. That's great advice. I think that's how a lot of law students get trapped in jobs they don't enjoy long term, is the pay.
Yeah. Yeah. Um, Plaintiff's work can be very, in long term, can provide very good income, but it often doesn't for those that are just starting out.
Yeah.
If you really want to do plaintiff's work, don't let that blind you.
Yeah. I think it was Louis that compared plaintiff's work to like medical school and residency. They don't throw you in your own practice making the big bucks your first year out. You get trained, you move up.
Yep. I think that's potentially a valid analogy.
Yeah. Something I might add for the law students, networking seems like a scary word, I think. I When I first started law school and they said, "You need a network," I thought, "I need to go to these big meetings, talk to all these attorneys." But it's just the small things too, like, I mean, you've become a great mentor for me, Louis has as well. Louis was at my first, orientation meeting at the law school, and I kind of found out about plaintiffs through him, and then he helped advocate for me for some other job opportunity I was looking at, and I think 3 out of 4 summer jobs I've had have not been from OCI, been from networking myself.
Yep.
So it's really a win-win. It makes it a lot easier for you. I remember writing dozens of cover letters that first year of law school for nothing. So it can really save you a lot of time, and you're more personally connected to the people you're interviewing with. You have better chances. So,
I agree with that. And I'll also add this kind of corporate response to your, it's very natural, I think, to feel what you were expressing. That is kind of being afraid of networking in the beginning. But what I'm about to say is true of at least the great majority, maybe not all, but the great majority of what I consider to be some of the very best trial attorneys. Their time is tight, but if they're going to be spending time with a young lawyer, what they really would love to do is to spend time with a young lawyer who is eager to learn and is thinking about the right questions to ask and is just coming, not saying I'm here just to get a job
yeah,
or even at all to get a job. It's just I want to learn. Can I come sit down with you, whether in your office or over a cup of coffee, 15 minutes, 30 minutes, 45, an hour, whatever is available, and just pose questions. I have found that when approached that way, most of what I consider to be very good, strong trial lawyers are very willing to share what they know, and then friendships develop and they become great resources. As you were mentioning in the movie, I think that's a great example.
yeah. I think you're touching on a good point. It's kind of the order of operations. You don't have someone come to the school and give a speech on plaintiff stuff, and then it makes me cringe when I see students run up and ask for a job after, because that's not why they're there. But they can be a mentor for you, and after a friendship has developed, that might lead to maybe they need someone later, but more likely they're probably going to have friends that do plaintiffs that need someone, because plaintiffs up and down. You don't constantly need clerks every summer. So, yeah, there's an order to it.
And I would add one more thing because it's impressive when you do what I'm about to say, and that is when you've had that sort of conversation, write a card, or just express gratitude. It's not so much about getting a card, it's just recognizing, wow, to take the time to just write a card or to send an email, whatever form it's in.
Yeah.
If there is sincerity there, it gives the lawyer the chance to think, okay, that was a good use of my time, and it helps solidify that connection.
Yeah. Yeah. That's great advice. That's all the specific questions I have. What other advice would you give? Anything I haven't covered to future trial attorneys?
I may have already said this, but it would simply be know why you want to do it. Such a believer in purpose. Are you being driven by a purpose that really matters to you, who you are? Understand what is significant to you, pursue purpose. And that's why I'm in Plaintiff. I very much appreciate the opportunity to serve purpose in that. And I just think it's a key thing to figure out.
Yeah. Great. Thanks for joining us, Jim. Once your book releases, I'll make sure to put a link in the show notes and people can check it out.
That's great. That's great. Corbin, I always enjoy working with you and visiting with you.
Thanks. You too, Jim.
Thank you.